A warm welcome to lesson number 21 in our 50-part series on the law of evidence. Today, we will be seeing section 15 of the Indian Evidence Act. Section 15 talks about certain facts that become relevant because they show that something was done accidentally or intentionally. Let us have a closer look. As always, let us start with a little reminder. The reminder is that we are looking at section 15, right? And section 15 lies between section 6 to 55. And 6 to 55 is basically chapter 2 of the Indian Evidence Act, which deals with the relevancy of fact, right? So we know that section 15 would be dealing with the relevancy of a certain fact. Now the provisions between 6 and 55 either declare that a certain fact is relevant or it declares that a certain fact is not relevant. So when you just glance at section 15 and you go to the end of it, what you can see is that section 15 is the kind of section that makes something relevant, which means section 15 basically says that a certain kind of fact is relevant, right? So that is what section 15 does for you. Now that we have this little background, just have a look at the title of section 15 and then pause the video and read the entire body of section 15. It's a simple section, straightforward, easy to understand. Okay, so as you can see, let's look at the title together. Facts bearing on question whether the act was accidental or intentional, which basically means that let us say there was an act, okay, which was committed. Now this act could either have been done intentionally or accidentally, right? Now how do you know whether it was accidental or whether it was intentional? Any fact that determines whether it was accidental or intentional is made relevant by section 15. Just pause the video and have a closer look at section 15. So what we know about section 15 is that section 15 is used when you have to answer the question whether a certain act was accidental or whether it was intentional. In such a scenario, we look to section 15 to see what other facts can be made relevant. Okay, so let's just have a look. When there is a question whether an act was accidental or intentional or done with a particular knowledge or intention, let's just stop here for the moment. Now, as you know, several times, especially in criminal law, the existence or non-existence of intention or knowledge, right, which is basically the mens rea, the guilty mind. So the absence or presence of the mens rea determines whether a person is guilty of the offense or not. Therefore, it is often important to know whether a person did something intentionally or whether it was done mistakenly, right? The other thing you can see is it talks about a particular knowledge or intention, right? So there are some particular types of intentions that are required for specific offenses. Like for example, when you talk of say theft, okay, there is a particular kind of mens rea that is required for it, right? When you say dishonestly, right, you will find the word dishonestly used in theft, which means it's a particular kind of intention, right? So when you have to determine whether it was done dishonestly or not, you're looking at a particular kind of intention. So these are the things that are often required to be seen when we are studying the law. And in order to know whether it was done accidentally, intentionally, or whether it was mistaken, you have to look at some other facts, right? Facts which determine whether it was accidental or intentional. Now we look at the second part. The fact that such act formed a part of a series of similar occurrences. Okay. So now you want to find out the relevancy of this fact. It becomes relevant only if you can see that it formed a part of a series of similar things. So he's done this in the past maybe, or there are several facts which form a part of a series. If something has been repeated, and then you're looking at the series in order to know whether it was intentional or not. Very simple. Let's just have a look at an illustration and it will make the point very clear. Okay, so let's have a look at the first illustration, illustration A. A is accused of burning down his house in order to obtain money for the insurance, right? So as you know, let us say you own a certain car, for example. Now, if you have a car insurance, what that means is that if the car suffers some damage, then you will get back the insurance money. Now, is that for accidents or is that for you intentionally going banging and damaging your car? right? So you know that it is not for intentional damage. It is only for accidental damage, which means that when you talk of, say, the car insurance, the question is important whether the damage was accidental or the damage was intentional. So you see, this is what section 15 deals with, whether the action was committed accidentally or intentionally. Now we look at the further part of this illustration. It says that the facts that A lived in several houses. So you have several houses. These are forming a part of the series. So this is house number 1, house number 2, house number 3, and house number 4. Okay. In each of which a fire occurred, and after which he received the payment from different insurance companies. Okay. So let us say we know that in his first house there was fire, he received money from the insurance company A. Second house there's a fire, he receives from B. Third house he receives from C. Now this time his house number 4 has caught fire. This is what is now come before the court, and the court needs to decide whether it is intentional or accidental. So it will look at the past, because these form a series, of similar occurrences, and this will help the court to decide whether it was intentional or accidental, right? So as you can see, when you see that somebody has perhaps had a fire several times and received insurance, then maybe it was not intentional, maybe it was not accidental, it was intentional. That's what you can infer by looking at the series. So therefore section 15 says that when you see similar occurrences that have occurred in the past, you look at them and then you can decide whether the act was intentional or accidental. Let us have a look at another illustration, illustration C. So illustration C says that A is accused of fraudulently delivering to B a counterfeit rupee, which means that A has delivered to B a fake currency, right? A fake coin, okay? Now, the question is whether this delivery was accidental or intentional, right? That's what section 15 deals with, whether it is accidental or intentional. Then it goes on to say that the fact that soon before or after this delivery to B, A had also done a similar delivery of a counterfeit coin to C, D, and E, right? So the fact that A has given it to C, A has given it to D, A has given it to E, these establish that maybe A was not doing it accidentally, maybe it was intentional. Therefore, this shows that it was not accidental but intentional, and therefore this thing, these three things here, the delivery to C, D, and E, is relevant under section 15. Alright, so as we saw, section 15 is a relatively simple provision of the Act. You can look at the remaining illustrations to get a clearer picture of section 15. Before I conclude this lecture, I'd like to discuss this important point about the overlap of sections. So generally, when we have a fact and we have to see whether it is relevant or not, then we look at a certain section. So let us say if a fact is found to be relevant under section 6, that is because it forms a part of the same transaction, right? Likewise, if a fact is found to be relevant under section 7, it is because it shows the cause or the effect of a fact, an issue, or relevant fact, and so on. Likewise, we saw in section 15 that section 15 shows you facts which show whether it is accidental or intentional, right? Now the point is that a given fact may be relevant under more than one section, which means it may be relevant under section 6 and section 7, maybe section 6, section 7, and section 8. Now let me give you an example by taking section 8 and section 15. Now, section 8 deals with intention, motive. There are more things to it, but for the time being, we'll just talk about facts showing intention or motive. Now let's take the same example that we'd taken in the beginning of the lesson for the first illustration. Let us say the house number 1, house number 2, house number 3, and then of course house number 4, which is now the matter before the court. So the matter is whether the burning of the house was intentional or accidental. Now when the court looks back at house number 3, house number 2, or house number 1, what it can gather from this fact, whether the burning of the first house and the second house and the third house, that also tells you his motive, right? So these things are also relevant under section 8. So I'm just giving you an example to show you that a fact can be relevant under section 8 as well as under section 15. So it is relevant if it is relevant under any one section. It may be relevant under 2 sections, it may be relevant under 3 sections. That does not matter. What we need is that a fact, for it to be relevant, should be relevant under at least one section, right? At least one section. So now that you've seen quite a few provisions, you would notice that there is an overlap that happens several times. So from now on, whenever you see a new section relating to relevancy, just see whether there's an overlap, and that will give you a clearer idea of how to understand these provisions. I hope this lesson made some sense to you. Thank you for your patience. Good day.